heard the majority judgment, which is what is prominent in this matter, but there was also a minority judgment. So let's focus on that now. I've got James Grant, Advocate James Grant from the Wits School of Law, who joins me now to discuss this. Advocate, thank you so much for making time. So the dissenting judgment by Justices Chris Japhta and Leona Theron agrees with the guilt of contempt of court, but it disagrees with the sentencing. They feel it's unconstitutional. What reasons are outlined for this position?
Good afternoon to yourself and the viewers. It would seem that at the base of their objection to the majority judgment is the extent to which fair trial rights should have been extended to Mr. Zuma. Fair trial rights are ordinarily those rights that an accused person who is accused of committing a criminal offence and who is then tried before a criminal court enjoys. And the concern might be, or is, of the minority that these rights might well have resounded to the benefit of Mr. Zuma in a way that the majority didn't consider.
Yeah. So do they indicate what punitive order they think would have been appropriate for this kind of contempt?
I haven't seen them express a difference in terms of the amount of penalty that would have been appropriate. No.
Yeah. So let's talk about what the former president has done, because he was provided with an opportunity to provide evidence as to what sanction would be appropriate if he is found guilty of contempt of court. How much of that did the court consider before deciding and going with the way that they went now?
I think that was the first signal to anybody that the Court was taking this issue very seriously, and that if it were to treat it seriously, as all indications were then, that it couldn't be seen to have simply ignored Mr. Zuma and not given him a chance to state his version. On the contrary, what we've seen is it going to extraordinary lengths, some might say, to elicit from him what it is that his version is, and even asking him what some say is beyond extraordinary, asking him what sort of penalty might be incurred. These are closer to the sort of rights that one would enjoy if one were an accused person. So you can see that even though the majority didn't take account of fair trial rights expressly, they nevertheless gave effect to at least the spirit of those rights.
Yeah. So when we discuss minority judgments, I mean, they're more academic, but I imagine they're also important perhaps for future cases. How significant are they really in the bigger scheme of things?
In the bigger scheme of things, it's quite simply a case of that the majority judgment outvotes the minority judgment. But one may often find pearls of wisdom in a minority judgment that in subsequent decisions are held to be actually the correct position, especially accused people or opposing parties might pick on arguments raised in the minority judgment to attack the majority judgment. And so they do certainly serve a basis. Sometimes you find that the minority, over time, the minority view prevails.
Yeah. And I mean, we're dealing here with the aspects of the case, Advocate. You know, the aspects of the case were so unprecedented. This was the first time that this court, the apex court, was asked to send someone to jail. The case was heard without Zuma participating, not even defending himself. So it's quite an important precedent. And as you said, there are some people that may take this opportunity to attack the majority judgments using the minority judgments. We've already started seeing that happening with those that support the former president. How does this judgment help the Commission of Inquiry into state capture? Advocate Thembeka Ngcukaitobi said when he was arguing in this contempt of case that we're not seeking Jacob Zuma's appearance, we are seeking his punishment. But some people have said, well, at the end of the day, he's still not going to appear before the inquiry. So how much does it really help the State Capture Commission?
Regrettably, it doesn't help in eliciting his testimony, which is the ultimate goal. Both the Commission and the Constitutional Court were put in the position of doing all that they could in order to elicit his evidence, subject, of course, to his right to silence and against self-incrimination. But the worst that it could do was to say, you must speak and tell us what you know without incriminating yourself. And if you don't, you'll be subjected to punishment. And that's the worst that both the Commission and the Court could do. And ultimately, as we've seen, Mr. Zuma has continued to refuse to talk. And so the or else has kicked in. It's now subjecting him to punishment.
Yeah, and I suppose it's also important to remember that this was a civil matter. This were civil proceedings in the Constitutional Court. We still have that criminal case. There was a case that was laid by the State Capture Inquiry. I suppose it's important to differentiate between the two. The fact that the Constitutional Court has ruled in this manner doesn't affect that criminal case. Is that correct?
That's correct. So previously the Commission laid a charge with the NPA under the Commissions Act, which provides for effectively what one might call contempt proceedings under the Commissions Act. But those proceedings are subject to a maximum penalty of 6 months in prison, whereas having referred the matter to the Constitutional Court for being in breach of the Constitutional Court order, the Constitutional Court wasn't under any limitation in the sentence that it imposed. Just on the final point of it being civil proceedings, they are a mix of, or contempt proceedings are a mix of civil proceedings and criminal proceedings. I am concerned, though, that there is going to be much made of the criminal element of the proceedings, in the sense that the argument, I expect, may be made that these were in truth really criminal proceedings and Mr. Zuma ought to have been afforded the rights of a criminal accused, and that line of attack might be raised to prolong matters once again.
Yeah. My last question, Advocate. The former president is due to appear in court, I think next month, for his corruption trial. What happens now? How does today's development affect that? Is he going to appear in court as an inmate?
Yes, he will appear in court. The appearance will be facilitated by correctional supervision. They will, however, have to make it very clear and be careful to avoid any indication that he appears before the court as a convicted person. So, for instance, he will be allowed to dress in civilian clothes and no restraints should be apparent to the court. And that's really to give expression to his right to be presumed innocent.
All right. Thank you so much for your great analysis and helping us understand the minority judgment, how significant it is, but also the consequences of this judgment on other matters as well. Professor James Grant from the Wits School of Law.